Good afternoon, everyone. Thank you for joining PHCA for today's webinar entitled Overview of the Department of Labor's Overtime Rules and the Impact on Employers. My name is Abby Foster. I am the Director of Marketing and Member Services at PHCA. Before we get started, I have a few housekeeping items to cover. This webinar will be recorded and made available on the PHCA website. This webinar has been approved for 1 continuing education credit for administrators, both skilled, assisted living, and personal care. Certificates will be emailed following the conclusion of this presentation, along with a link to the slide deck and link to the Department of Labor frequently asked question page that was sent to you in your webinar reminder email. All attendees will be in listen-only mode. Throughout the presentation, please feel free to submit questions via your questions pane on the right-hand side, and our presenter will address them at the end of the presentation. On May 18, 2016, the U.S. Department of Labor formally announced its final rule, which more than doubles the minimum salary threshold for executive, administrative, and professional employees to qualify as exempt from overtime pay under the Fair Labor Standards Act. The Department of Labor estimates that the final rule, which is set to become effective December 1st, will extend overtime pay eligibility to 4.2 million workers and result in $1.2 billion per year in additional wages paid to employees. This webinar will accomplish the following: provide an overview of the provisions of the Department of Labor's new overtime rule, examine how the final rule will be implemented, and discuss how employers should assess the final rule's impact on individual employees and departments, as well as its effect on workflow and business operations. Our presenter today is Andrea Kirshenbaum of the law firm Post and Schell in Philadelphia. Andrea is a principal in the firm's Employment and Employee Relations and Wage and Hour practice groups and a member of the firm's appellate department. She defends employers nationally in federal and state court litigation involving all major employment statutes, represents them in related government investigations, and counsels them proactively on compliance with these statutes. Thank you, Andrea, for being here with us today to offer your expertise on this rule. We can now begin the live presentation.
Thank you very much, Abby, and thank you all for joining us today. Abby gave a good overview of what we're trying to accomplish today. The first goal is to provide you with an overview of the Department of Labor's final rule, which is going to impact your workforce, and then we're going to spend a lot of time talking about practical tips and suggestions that I have for how to implement the final rule. I have a disclaimer slide here. I won't read it to you, but obviously the presentation is not seeking to offer you specific legal advice. So just to give you all some brief background so that we set the stage here, last year the Department of Labor issued a notice of proposed rulemaking, which contains a proposed increase in the minimum salary threshold for workers to qualify for the white-collar exemptions under the Fair Labor Standards Act. And just to take a brief step back, obviously, the Fair Labor Standards Act applies to most employers. There are certain coverage provisions, and unless an employee is exempt, either from overtime or from minimum wage, the default rule is that all employees need to be paid at least $7.25, the minimum wage, and need to be paid overtime, time and a half, for hours worked over 40 in a work week. And so what we're talking about today, the white-collar exemptions, are provisions which provide that if you meet all of the requirements for the white-collar exemptions, and we're going to talk about what those requirements are in a minute, then those employees are exempt from the requirements of the FLSA to be paid overtime. And the proposal, which was made last year, is higher than ultimately what the proposal was that, or the final rule that was issued by the Department of Labor recently. Currently, the salary level in order to be exempt under the white-collar exemptions is $455 per week, and that equates to $23,660 per year. That level was set when the white-collar regulations were revised in 2004 under the Bush administration, and that level has not been increased since then. And the President in 2014 had asked the Department of Labor to propose revisions in order to update the regulations Obviously, the number doesn't increase over time, although we'll talk about the Department of Labor's final rule, which would increase it over time going forward. But up to this point, there's not been any mechanism to automatically update the regulations, and therefore, as time goes on, they erode for inflation. The Department of Labor, when they issued the proposed rule last year, estimated that on an annual basis, workers would earn roughly $1.2 to $1.3 billion in additional wages. The proposed salary level was $970 per week, and as we'll talk about in a minute, the final rule is slightly less than that, and we'll also talk about the other key provisions of that rule. In order to meet the white-collar exemption requirements for the exemptions we're talking about, sometimes we refer to them as the EAP exemptions as well, executive, administrative, and professional. I think about it as like a stool, like a three-legged stool. You need to meet each of the following requirements in order to satisfy the obligation to meet those exemptions. And we're really going to be focusing mostly during this time on the third, but it's important not to lose sight of the first and the second as we're focusing on the third. First, an employee must be paid a predetermined and fixed salary that's not subject to reduction because of variations in quality or quantity of work performed. So if an exempt employee comes to work, whether they work for an hour or 10 hours, they're still making that salary, and you're not taking deductions from pay if they don't meet a quota or for any other reason. The second requirement is the duties requirements, and again, there's not been any changes to those duties requirements here, but it's important as we're looking at the changes that are in place to not lose sight of the other requirements. An employee's job duties must primarily involve whether it be executive, administrative, or professional duties, so they still need to meet those duties tests. And the third requirement is the amount of salary must meet a minimum specified amount. Currently are $455 per week, which equates to $23,660 per year. We're also going to briefly speak about the highly compensated exemption. It's another exemption in addition to the white-collar exemptions, and the thought process behind the highly compensated exemption is that employees that receive a certain very high salary don't need to meet all of the tests to meet the executive, the administrative, or the professional exemption. So it's a relaxed duties test if there's a very high salary. And currently the highly compensated employee salary level is $100,000. And that needs to be paid on a per year basis, and at least $455 per week needs to be paid on a weekly basis. So if you have a highly compensated employee, currently they have to earn a salary on a weekly basis of the $23,660, and the rest of the compensation can be paid in any other way as long as it's paid within the year, and that employee needs to customarily and regularly perform at least one of the exempt duties or responsibilities of the executive, the administrative, or the professional. And obviously, this is going to be a very small subset of your workforce. What we're going to be focusing on today is the increase in the general salary level. I also wanted briefly to mention the DOL's final rule in 2004, because I think that some of the DOL's thinking in issuing these regulations and their rationale behind them dates back to the changes that were made in 2004. Prior to the 2004 regulations, there were two sets of tests in order for employees to meet the requirements to be exempt. There was a long test that had more onerous requirements, and there was a lower salary attributed to that. And then there was a short test for employees who are paid a higher salary. In 2004, the Department of Labor collapsed that and provided for one single duties test. And the standard duties test didn't have certain percentage requirements. The long test had percentage requirements, but now it's a primary duty analysis, not a percentage of time analysis. So as Abby was saying, May 18th of 2016, President Obama and Department of Labor Secretary Perez announced the publication of the Department of Labor's final rule, updating the overtime regulations, and the estimate is that it will extend overtime pay protections to over 4 million workers, absent intervening employer action, and we're going to talk about that intervening employer action in a little bit. The effective date of the final rule is December 1. So we all should circle that date on our calendar, although we'll talk about it in a minute, it's a Thursday. So I think everyone needs to probably have their plans in place and maybe a dry run or two through before that time period, of course. And the most significant aspect of the final rule, and what everyone has really been hearing about in the media, is the increase of the salary level from $4.55 to $9.13 per week. And there were over 270,000 comments that the Department of Labor received in response to the proposed regulations, which is really a phenomenally large number. Those comments were made over a 60-day time period. And some of those comments specifically asked that the salary level be increased slowly over time, and that is not something that the Department of Labor agreed to do. So as of December 1st, the salary level goes to $9.13 per week. And again, in order to maintain exempt status under the administrative, the executive, and the professional exemption, employees now need to be paid $913 per week, which equates to $47,476. And we're going to talk a little bit about 10% bonus being credited to that in a little bit. But for the most part, that's what we're looking at. The highly compensated exemption has been increased, and it's gone from $100,000 to $134,004 per year. The other really significant aspect of the regulations is that in the future there are going to be quote-unquote automatic updates to these salary threshold levels, which are going to occur every 3 years, beginning January 1st of 2020. So the first and most significant aspect of the rule, and what we're going to spend most of our time talking about, is this increase in the minimum salary threshold. This is slightly less than $3,000 below the level that was in the proposed regulations. The proposed regulations were to key the number to the 40th percentile of weekly earnings for full-time salaried workers across the United States, across the country. There were a lot of comments the Department of Labor received suggesting that there was real differentials in the cost of living across the country, and some commentators asked that the Department of Labor consider having different salary levels for different parts of the country. Ultimately, the Department of Labor rejected that approach, but what they did agree to do is to look at the 40th percentile of weekly earnings for full-time salaried workers in the lowest wage census region rather than across the country. So that lowered that number a little bit. Currently, the lowest wage census region is the South. The second key provision of the final rule is that increase in the annual compensation requirement for the highly compensated exemption. And again, that number is $134,004. And that is the 90th percentile of full-time salaried workers nationally. And that's actually about $12,000 higher than the proposed level. And you'll see that while the Department of Labor did change the number to the lowest census region for the EAP salary level, for highly compensated, the Department of Labor maintains that national number, which makes it a little higher. The third significant aspect is this automatic updating. And I will say that I do think that this will be challenged in litigation. Whether that litigation ultimately will be successful, we obviously don't know at this point. But I think at this point, we should assume that that your plan should take into account that there will be this automatic update, although it may be challenged in litigation. The Department of Labor will announce the new minimum salary level at least 150 days before its effective date. So in August of 2019, again, assuming there's no legal challenge that's successful to this automatic updating, the Department of Labor will announce on its website and also publish in the Federal Register the salary level, and it will continue to be the 40th percentile of full-time salaried workers in the lowest wage census region at the time of updating. The Department of Labor, in the compliance materials that it's provided, has indicated that it currently estimates the salary level in 2020 will be $51,168. I would caution you all that this number may be significantly higher because it's unclear whether the Department of Labor has taken into account what I would call the echo effect. So if a lot of businesses increase the salary level of certain employees who are near the salary threshold in order to maintain their exempt status, and then those salary increases are going to be counted in analyzing what the 40th percentile of full-time salaried workers is, that number might become higher or significantly higher than this $51,000 number. So that's something to keep into account and in the back of your mind as you're implementing these changes, that it's a pretty big question mark what this level is going to be in 2020. The fourth aspect of the final rule is that the Department of Labor has agreed that non-discretionary bonuses, so incentive pay, commissions, of up to 10% of the salary threshold paid on at least on a quarterly basis can be counted towards the minimum salary requirements. And this is only for the executive, administrative, and professional, not for the highly compensated. So for instance, if you have an employee who makes 913 minus 91, then they would need to, by the end of the quarter, have earned in non-discretionary bonuses that differential in order to remain exempt. And then if they didn't earn that, you would have one pay period to make a catch-up payment to the employees in order to maintain the minimum salary requirement. If you decided not to provide the catch-up payment, then you would have to reclassify the employee and determine how many hours they worked and pay them overtime on a retroactive basis. So I do think that the thinking behind this is many employers in their comments indicated that a substantial portion of employee pay is often made in commissions. And so this was the Department of Labor's attempt to try to permit employers to take credit for a small portion of those commissions. I do think that it will be challenging to implement this in practice, and I think that any employer who's trying to take advantage of this 10% should proceed with caution and make sure that that they understand and appreciate what the implications are and that they're careful in its implementation. Also, it may make sense if there's consideration that the employee may not meet the number and they don't want to make the catch-up payments, to keep track of the employee's hours so they would know what, if any, overtime would be due to the employee if they're working over 40 in a work week. So when the proposed regulations came out, the Department of Labor had asked several questions about the duties test. And many in the regulated community were concerned that we were going to see some changes to those duties tests. The final rule does not include any changes to the duties. The final rule also applies to the computer professional exemption, and the hourly rate is $27.63 per hour. Also, it's important to note that for any of you out there that pay employees on a fee basis, the adequacy of the fee basis is now going to be tested against this new salary level. So you should be aware of that if you have any fee basis employees. I wanted to touch on this briefly, and I did send out the FAQ document from the Department of Labor in the materials that went out for the webinar. But the Department of Labor issued in the Federal Register at the time that the regulations came out a limited non-enforcement policy specifically and only for Medicaid funded services for individuals with intellectual and developmental disabilities in residential homes with facilities with 15 or fewer beds. So by its terms, the regulations still apply to those facilities, but the Department of Labor has indicated that it will not enforce the updated salary threshold from December 1st, 2016 to March 17th, 2019 for that limited subset only. I would caution anyone who this impacts that the Department of Labor's decision to forbear and not to enforce does not affect private enforcement. So merely because the Department of Labor is not going to come knocking on your door, that wouldn't prevent a private plaintiff and a private plaintiff's attorney from challenging the payments made to workers after December 1st if they don't comply with the new salary requirements or new regulations generally. The Department of Labor, in its materials that it's issued, and I would say that if you all are, working through these issues and have any questions, obviously you can certainly reach out to me and I'll try to answer some questions at the end if we have some time for them. The Department of Labor has really provided a lot of compliance material on its website. And so I would commend you to the website, and there are a bunch of FAQs and compliance materials. Employers really do have a wide range of options for responding to the changes in the salary level, and we're going to work through the process of thinking about that right now. There's our calendar, and December 1st is a Thursday. So again, I think probably everyone should try to put the final touches on their plan before that time, and certainly maybe before Thanksgiving, and then try to do some trial runs. So really, obviously, the first order of business is for you all to look and see who in your workforce is going to be directly and indirectly impacted by the regulations. How many employees do you have currently who are exempt under the administrative, the professional, or the executive exemption, who are earning between $455 and $913 per week, that need to be considered either for reclassification as non-exempt or increase in their salary in order to maintain the exemption? Who are they? What departments are they in? What impact would reclassification have on them? I mean, the first order of business is to figure out who we're talking about, and the second is to look and think about, are they working overtime? Because if they're not working overtime, if you reclassify them and they're not working over 40 hours, then you're not going to have to pay them overtime. Obviously, you're going to have to rethink how you keep track of their time if they're a non-exempt employee, but it's not going to cost the organization additional money if they're not going to be working overtime. So that's the first order of business, to figure out what it is that we're looking at here. And I mentioned here that the final rule may have the unintended consequence of creating some salary compression, because, and I'm sure you can appreciate, if you have a bunch of people making 44, 45, 46,000 who you decide, because of the substantial overtime they work, or because they work remotely, or for various reasons you want to increase their salary level in order to maintain their exempt status, is that going to impact the amount of money you have available for raises for other people? Are you not going to be able to give a raise or increase the salary of your folks who make $49, $50, $51, $52? And is there going to be some salary compression? I think that one of the most significant challenges with this regulation is the employee relations aspects of it, and managing through those is going to be really essential in putting together a comprehensive plan for managing. Once you figure out exactly what you need to do in terms of whether you're going to reclassify certain people, whether you're going to change certain people's job duties, and for various reasons, and we'll talk about it in a minute, I think having a really strong communication plan for your workforce where everyone understands what's happening and why it's happening is it's critical. And I know that, December 1st is a challenging date because obviously people are out for Thanksgiving and people gearing up for the holidays. And so I think, these are plans you all want to think about over the summer, trying to put in place and evaluate the impact of these regulations, certainly sooner rather than later. So I've spoken with some plaintiffs' counsel with regard to these regulations, and they've expressed to me that they anticipate that the changes will result in a significant increase in litigation in two areas. The first is that as employees are reclassified because of the regulations, some employees may question whether they have been properly classified as exempt in the past, and that may cause them to go see an attorney. And so in the short term, what I'm hearing from my colleagues in the plaintiff's bar is that there may be a burst of misclassification litigation around the time of and within, 6 months, 9 months of the regulations going into effect. The longer-term litigation that the plaintiffs' counsel anticipate is really an increase in what we call off-the-clock litigation, allegations that employees are being pressured to work off the clock and not report that time in order to keep budgets in line, and that this will be especially so if there is no increase in headcount. And so the argument, I would expect it to go as, well, Johnny used to work 60 hours, and now he's been reclassified as non-exempt and told he can't work more than 40 hours because they need to really closely manage overtime. Yet Johnny's work requirements maintain or the same as they were when he was working 60 hours. They had to have known that he could not accomplish all of the tasks that he was given in 40 hours because he was accomplishing those tasks and he needed an extra 20 hours to do that previously. And therefore, they knew, or they should have known, that essentially by doing what they were doing, they were causing him to work off the clock. So this is what I'm hearing from some plaintiffs' attorneys, and so this is something to really be mindful of as we go forward. So in terms of planning and response ahead of our December 1st compliance deadline, I think first and foremost, employers should conduct a comprehensive review of the workforces to, again, identify which individuals are going to be directly impacted. But I think it's important not only to focus on those individuals, but also to analyze the impact of the regulations on the workplace more generally. So if you're going to reclassify someone, how many hours are they going to work? What impact are those hours and those changes going to have on the workflow of the department? What impact are those changes going to have on the coworkers who either continue to be exempt or continue to be non-exempt? And so I think that there are significant implications for reclassification, not only for that reclassified worker, but more broadly for the department. And the analysis is similar to a wage and hour audit. I think organizations should be very careful in how they communicate compliance efforts, discuss the changes, because we all know that sometimes email is forever, and so I think everyone should be careful how they communicate and whether those communications are attorney-client privilege. If you're reviewing compliance, you should consider conducting the review under the ambit of attorney-client privilege with your in-house counsel or your outside counsel in order to prevent disclosure of those materials from later litigation should it occur. I think as you're clearly getting the sense, while these are legal regulations, there are implications for finance here in terms of potential increased costs of overtime, for operations and workflow, and for employee relations professionals to really be involved. I think what we saw with the 2004 regulations is that many people who were reclassified expressed concern that they felt like they were being demoted. While, it may well be that they appreciated the overtime, if you're an hourly employee, you're clocking in and you're clocking out, and so you may have less flexibility. So I think managing that is an important aspect of things as well. So obviously, if you have an employee who is near the new salary level, they're working significant hours over 40, some employers are going to want to increase their salary to the level so that they can continue to classify them as exempts and not have to pay them overtime for hours worked over 40. But again, I would caution you all that employers providing those raises in order to maintain exempt status should be aware that this is a 3-year solution. This is not a permanent solution. So it remains to be seen what will happen with this automatic updating, but as of now, the automatic updating is part of these final rules. They will go into effect December 1st. So before you all decide to increase someone's salary, you should think about whether you're going to be in a position to pay at least that $51,168 come 2020. And if not, it may make sense not to increase the salary level, because if you increase the salary level now and then later you're going to take the person and you're going to make them non-exempt, you've now increased potentially their hourly rate of pay for purposes of overtime. So employees that are making at least more than a few $1,000s less than the salary threshold we're talking about, probably you're going to seriously consider them for reclassification. And the question then becomes, if the person was salaried, do you want to maintain them as salaried? Do you want to pay them on an hourly basis? How many hours do you want to assume that they're working? And if currently those employees aren't clocking in and clocking out, because if they're exempt, they may not be, how many hours have they been working? And if you don't know the answer to those questions, it probably makes sense to have employees you're considering for reclassification put into place some kind of pilot program for them to keep track of their time so you can get a better sense of how many hours they're working, and then make educated decisions about how to set their hourly rate of pay going forward. Do you want to keep their rate such that you leave room for overtime? And how many hours of overtime? So while I think the Department of Labor's public relations on these regulations suggests that the regulations are uniformly going to be positive for employees, it may be that if you have an employee who their salary is going to turn into an hourly rate, and then the hourly rate is going to take into account X number of hours of overtime, certainly in the weeks where the employee doesn't work those X number of hours, it's possible that employee could be earning less. So I think that the impact of the regulations are far more complex and individual specific than I think, sort of the uniform messaging has been. The other thing to think about is to consider changes to job duties of workers or broader restructuring of job classifications. Often under this set of circumstances, it's useful to dust off those job descriptions and see if they truly fit. And are John and Sally really doing the same job? Should you create a different job description in the job family, or does it make sense to then take someone's duties, the lower level duties potentially, and consolidate them with someone who maintains a non-exempt status, but then consolidate more of the exempt duties with someone else. I mean, it's going to be very situation specific, and so it's really a department by department, employee by employee analysis as to what makes sense operationally as well as compliance-wise. Given the ability to count up to 10% of non-discretionary bonuses and commissions toward the salary requirement, if you're considering doing that, you all should be looking at your bonus and commission plans for the affected employees and consider what, if any, modifications are necessary in order to ensure that those plans comply with the requirements to take that 10% credit, I'll call it, but take the 10% amount for non-discretionary bonuses. Also, if hourly workers and salaried workers receive different types of benefits and the regulations are going to cause you to reclassify salaried workers as hourly, what impact is this reclassification going to have on the benefits available to those reclassified employees? And should you consider making any changes to benefit plans to mitigate that impact potentially? If a significant number of employees are being reclassified, how are they going to track their time? And what impact is that going to have on operations and workflow? For all of your exempt employees who are becoming non-exempt, do you really want them to continue to have electronic devices, access remotely? You may not want that from a wage and hour compliance perspective, but operationally it may be a much more complex question. So if you decide that you have a newly reclassified employee who you need to have an electronic device and provide remote access to, what measures are you putting in place to make sure that you are keeping track of that time and that employee is being paid for all time worked? Also, you should look at staffing patterns. What opportunities are there for efficiency? I mean, I think that while these regulations certainly pose significant challenges for employers, I think, you know, employers should look broadly at the impact and look at the workforce and see if you're already making certain changes, what other changes might make sense as well. Obviously, if we're going to be dealing with additional overtime, how do you financially forecast that? You budget it to make sure you're accounting for that going forward. Also, the Fair Labor Standards Act, when it was passed during the Great Depression, and so one of the key aspects of it was to provide for a minimum wage, a floor below which employers could not pay. But the overtime requirement was really created to try to spread work and reduce the unemployment rate. So it really disincentivizes or attempts to disincentivize working employees more than 40 hours because you have to pay that premium level. So if employees are working less than that 40, you don't have to pay that premium. So assess whether to hire additional workers to try to reduce the need for overtime. Although there were no changes to the duties test, it's a good time to consider whether there are certain employees whose classification may be at the margins, and you may want to consider for reclassification from exempt to non-exempt. Or again, bolster the exempt status of certain positions by reconfiguring the job family or the department, consolidating the exempt duties or more of the exempt duties in one position and more of the non-exempt duties in another position. Obviously, that has employee relations implications as well, but it's certainly, as you're looking and considering changes, it's something certainly to consider. And as I mentioned before, the communication piece is critical, especially for reclassified employees who may perceive the reclassification as a demotion. So once you've evaluated your workforce, determined how you want to proceed, assessed who you want to or need to reclassify, and communicated with the employees what it is you're needing to do and why. And I do think it's important as you're communicating to make sure employees understand that this is not because you don't value them, that you're doing this because the Department of Labor issued these new regulations, and this is what you're required to do in order to comply with the regulations. I think that that's an essential aspect of the communication piece. And then training regarding new practices. Employees who aren't used to clocking in and clocking out, I think, there's going to be an adjustment period. And again, running drills, making sure people know exactly what to do before you go live. I also think that not only training for these newly non-exempt employees, also training for management, because if management is used to managing a largely exempt workforce and now they're managing many more non-exempt employees, making sure managers understand that employees need to be paid for all time worked, making sure that there's a procedure in place that they're aware of, so that if an employee works remotely, there's a form or some process to fill out to be paid for that time. So the training piece is really important, both for management and for these newly reclassified employees. The other thing that's really important to remember, and this whole presentation has been about the Fair Labor Standards Act and the final rule issued by the Department of Labor revising the white-collar regulations for the Fair Labor Standards Act, but the FLSA is a floor below which employers who have to comply with it cannot go. But it's essential that employers always be aware of state law, sometimes local law, and so I know that we're sitting here in Pennsylvania with all of you in Pennsylvania, it's important to remember that there are some significant differences as between the FLSA and the Pennsylvania Minimum Wage Act, and so always to be aware of that and make sure that that by complying with the FLSA, you're not ignoring the requirements of Pennsylvania law. So with that, if anyone has any questions for me, I'm happy to answer them. I think just very briefly, the two questions that I've been getting a lot from people, so it may be on your mind. The first question that I've been getting is, what about part-time employees? And there is no exception or difference part-time employees or full-time employees. If someone doesn't meet that 913 per week, irrespective of the number of hours they work, they cannot meet the requirements for the executive, the administrative, or the professional employee. So there is no different standard or different salary level for part-time. The second question that I've been getting a lot of is, okay, so what do we do if we have two employees? One of them is more experienced than the other, but they both perform the same job. They essentially have the same job duties, but for one of them having some more experience, they sit side by side. One of them makes $44,000 and one of them makes $48,000. So can we really classify them differently if they're performing essentially the same job and they're in the same job classification? And I think, from some employers, what I'm hearing is, well, we have made an organizational decision that we don't want to do that, that everyone in the same job description, we want them similarly classified. And that is a totally reasonable approach. I think there's no one-size-fits-all answer to this. I do think that it would be reasonable to have one of them classified as exempt or non-exempt, because the focus isn't on the duties, the focus is the salary level. And so I think there's no right answer there. It does create employee relations issues to have two people sitting side by side performing essentially the same job, one of them being eligible for overtime and one of them not being eligible for overtime. But I do think that's a potential impact of the regulation. So I caution you that if your organization decides that, or becomes in that position and decides that they're going to have someone in the same job classification be exempt and someone else be non-exempt, that there may be some pretty significant employer relations considerations to manage. But it's something to be aware of, and it's a question that I've gotten a fair amount. So with that said, I don't know if anyone has any questions for me that they're hoping for me to answer. I often find when I give this presentation, people come to it with specific questions or concerns that they have in mind that they're looking to address.
Thanks, Andrea. We'll leave the question and answer portion open for a minute more. If you have questions, you can submit them on the right-hand pane on your viewer. We'll pause for another minute or so. If anyone has any questions, you can submit them.
Thank you, Abby. I appreciate it.
The presentation seems to have been so thorough that there are no questions. So thank you, Andrea, so much for this presentation. Again, to attendees, your certificates will be emailed before the end of today, and a recording of today's presentation will be made available at phca.org. Please feel free to share. Thank you again to our speaker, Andrea Kirshenbaum of Post and Schell. This concludes today's webinar.